He placed his leather portfolio on the defense table like it was a credential, like the object itself was proof that this room, my room, was a formality he had already mentally cleared. He was 22 years old. He had his father's name, and in 22 years, not a single room had ever told him that was not enough. I was about to be the first. But what I want you to understand, before anything else, is who was sitting 5 feet away from him. A 61-year-old woman in a pressed gray cardigan, reading glasses hanging from a beaded chain around her neck, a compression bandage wrapped from the base of her thumb to the middle of her forearm, her sewing hand, which she rested flat on the table in front of her with the careful stillness of someone who has learned, through pain, exactly how much pressure still hurts. She had run a tailoring shop on Carver Street for 14 years. He had been inside it for 11 minutes. If you believe that a name, any name, should not function as a shield in a courtroom, stay with me for every word of what happened next. And if stories like this one matter to you, please subscribe right now. This channel exists for exactly these moments. Her name was Evelyn Marsh. Officer Sandra Okafor presented the facts the way good officers do, plainly, in order, without decoration. At 6:09 on a Thursday evening, 4 months before this morning, a young man named Connor Dalton entered Evelyn's shop to pick up a suit jacket he had left for alterations 11 days earlier. The bill was $55. He said he had been quoted $30. Evelyn produced the work order. His signature was on it. His initials were next to each itemized charge. He swept it off the counter. Then he swept an entire display rack of finished garments off its stand. When Evelyn stepped around the counter and asked him to leave her shop, he grabbed her forearm and twisted it. Then he shoved her backward into the shelving behind her. She went down. Her hand caught the edge of a metal bracket on the way. The hairline fracture to her first metacarpal, the bone at the base of the thumb on her sewing hand, required 6 weeks in a brace. The medical bills and the income she lost while she could not work came to $8,400. She had not worked at full capacity since. 37 minutes after walking out of Evelyn's shop, Connor Dalton went to the nearest police station and filed a report. He told officers that Evelyn Marsh had attacked him with sewing shears, that she had lunged at him, that he had restrained her in self-defense. I let that sit in the air for a moment before I continued reading. Then I looked up at Evelyn. "Ms. Marsh," I said, "what are you asking this court for today?" She did not hesitate. "I want the false report removed from the record," she said. "It has already been used against me twice, against my insurance, against my lease. I have run a clean business on that street for 14 years. She paused. "He was in my shop for 11 minutes and tried to take that from me on his way out the door." She said it without bitterness, without performance, simply as a statement of what had happened and what she needed. The courtroom was quiet. Connor Dalton exhaled slowly through his nose. He leaned toward his attorney and said 3 words at a volume he did not bother to lower. "This is embarrassing." Then he straightened up, and he introduced his father. He said it without raising his voice. His attorney had already been in communication with the city's legal office, he explained. His father was Mayor Gerald Dalton, currently in his 2nd term. The appropriate resolution, Connor said, was a dismissal of all charges pending a departmental review of the responding officer's conduct. He recited it the way someone recites a procedure they have been told will work, not as a threat, not as a request, as a sequence of steps he expected the room to follow. I have heard powerful names introduced into this courtroom before. It is never the name itself that requires my attention. It is the calculation behind it, the specific belief that the name changes the arithmetic of what is about to happen. Connor Dalton believed it changed everything. He said it with the flat calm of someone who has never had to raise his voice to get a result. I looked at him directly, not at his attorney, at him. "Mr. Dalton," I said, "did you file a police report claiming this woman attacked you with scissors?" He looked at his attorney. His attorney began to speak. I raised one hand. "I asked you." Connor looked back at me. He chose his next words very carefully, the way people choose words when they are selecting them for their legal weight rather than their truth. My attorney advised me, he said, that the report was a protective measure. I nodded once. Then I told the clerk to place a call. Not to Connor's attorney, not to the city's legal office, not to anyone on a private list, to Mayor Gerald Dalton's direct office line, the number listed in the public directory, on speaker, in open court, in front of every person seated in that gallery. Connor's composure broke for the first time all morning. You don't need to do that, he said. Mr. Dalton, I said quietly, you introduced your father into these proceedings. I'm simply following your lead. 3 rings, a receptionist, the case number provided, a request to be connected to the mayor, 47 seconds of hold music. No one in that courtroom said a single word during those 47 seconds. I have been in this room for a long time. I have rarely felt a silence that heavy. Then the line opened. Mayor Gerald Dalton's voice was warm, practiced, the kind of warmth an elected official develops over years of turning difficult conversations toward the outcome they need. Judge, I appreciate the call. I understand there may be some confusion around my son's matter, and I want to assure you we are fully cooperating. I interrupted him, at the same volume I use for everything in this room. Mayor Dalton, your son is before this court on charges of aggravated assault causing bodily harm, destruction of private property, and filing a false police report against a 61-year-old woman whose sewing hand he fractured. A pause. I am going to ask you to remain on the line while the evidence is presented. A longer pause. Then quietly, of course. The shop's security camera footage played on the screen at the front of the courtroom. Timestamp, 6:09 p.m. Connor entering. The counter exchange. The work order produced. Swept to the floor. The display rack going over. Evelyn stepping around the counter. The grab. The twist. The shove. The shelving coming down. Her hand catching the bracket on the way. Connor walking out. Door closing. 41 seconds. From the first sweep to the last sound. 41 seconds. Connor watched it without moving. His jaw was set. His hands were flat on the table. Evelyn did not watch it. She had already seen it. When the footage ended, the courtroom did not make a sound. Not a shift, not a breath loud enough to hear. I read aloud the relevant section of Connor's police report. His statement to the responding officers that Evelyn Marsh had brandished sewing shears and lunged at him, forcing him to restrain her in self-defense. Officer Okafor confirmed. No shears found in the vicinity of the alleged attack. No physical evidence consistent with a lunge. One party with a documented injury requiring 6 weeks of medical care. I looked at Connor. Mr. Dalton, I said, were you in fear for your safety? He said, I felt threatened by a 61-year-old woman asking you to leave her shop. He did not answer. Then Officer Okafor said, Your Honor, there is a second layer. The second layer was not the assault. The assault was on that footage. 41 seconds, complete, beyond dispute. The second layer was what the false police report had been used to do after Connor filed it. 3 weeks after the incident, a letter was sent by Connor's family attorney to Evelyn's business insurance carrier. It cited the police report as documentation of a pattern of aggressive behavior on the part of the shop owner. It requested a full review of her business liability coverage. The carrier opened a review. That review was still active. Evelyn's renewal was pending. A second letter was sent to her landlord. It referenced the same police report. It described the shop as an elevated liability risk to neighboring tenants and suggested he consider that risk when deciding whether to renew her lease. Evelyn's lease came up in 6 weeks. Her landlord had not confirmed whether he intended to renew it. I let both documents sit in the record without speaking. On the phone, Mayor Dalton's voice came back quieter than it had been. I wasn't aware of the letters. Connor turned toward the phone for the first time all morning. His eyes went to the speaker on the clerk's desk. What crossed his face was not guilt, not yet. It was something earlier than guilt. The first moment a person realizes that a structure they believed was solid has shifted, and that the shift cannot be undone. Then Officer Okafor continued. The false police report had triggered an automatic flag in the department's record system. An internal review had been completed 3 weeks after filing. That review found Connor's report to be materially false in 4 specific particulars. A formal recommendation for a false report charge had been sitting in the department's pending file for 6 weeks, waiting for the conclusion of this proceeding. Connor's leather portfolio slid from the edge of the table. He caught it. His hands were not steady. "Mayor Dalton," I said, "are you still on the line?" He was. I asked my next question at the same level I had used all morning. No shift in tone, no pause to signal what was coming. "Were you aware that your son filed a police report that your own department has formally determined to be materially false?" The silence that followed was long enough to mean something. It was not the silence of a man composing his answer. It was the silence of a man who has started 3 different answers and stopped each one because none of them could survive what had just been placed in the record. When he finally spoke, his voice had lost all of that practiced warmth. He began a sentence, stopped, began another, stopped again. Then quietly, "What can be done here?" I said, "That is the first honest question I have heard from your family this morning." I looked at Evelyn Marsh. "Ms. Marsh," I said, "would you like to address the court?" She set her reading glasses on the table in front of her. She took one breath, and she spoke, without notes, without looking at Connor, to the room. She said she had been on Carver Street since she was 47 years old. She opened that shop with $6,000 in savings, a domestic sewing machine, a folding table. She had altered wedding dresses and school uniforms and the suits of men going to job interviews they could not afford to fail. She had employed 3 part-time workers over 14 years, all of them from the surrounding neighborhood. Then she said this, "The fracture will heal. What I need this court to understand is that the report he filed was not an afterthought. It was a strategy. The strategy was to make me the problem before I could make him accountable." The courtroom did not react with noise. It reacted with stillness, the particular stillness of people who have just heard something said with more precision than they expected. Then Connor Dalton's face broke, not slowly, not with warning. His face simply gave way, the way a face gives way when everything a person has been holding together releases at once, and what is underneath is not what they expected to find. His attorney placed a hand on his arm. Connor shook his head without looking at him. From the speaker, Mayor Dalton's voice came through, quiet now, stripped of everything official. "Connor," Connor said, not to his attorney, not to me, but to the table in front of him, "I didn't think it would go this far." I said, "It went exactly as far as what you did required it to go." I ruled from the bench. I want you to hear every part of it. On the assault, 180 days suspended, 2 years of formal probation, mandatory anger management and conflict resolution counseling, with documentation filed to this court every 30 days. Full restitution to Evelyn Marsh. The $8,400 in documented medical expenses and lost income paid in full within 60 days. A court-supervised assessment of any additional income lost between today and her lease renewal date, with that amount paid within 30 days of its completion. The false police report charge was forwarded to the city attorney's office for prosecution as a separate matter, fully supported by this court's record. The 2 letters, to the insurance carrier and to the landlord, were to be formally retracted in writing by Connor's family attorney within 72 hours, copies filed with this court upon transmission, and the community service requirement, 150 hours at small business development programs in the neighborhoods surrounding Carver Street. Not ceremonial work, administrative and operational support, the filing, the scheduling, the unglamorous and necessary labor that keeps those programs running for the people who need them. Connor's attorney rose. "Your Honor, regarding the placement," I raised one hand. "The placement is not negotiable." On the phone, Mayor Dalton said, "Judge, we will comply fully. I said, "Compliance is the floor, Mayor Dalton. It is not the standard I would encourage your family to aim for." A pause, then silence. As the bailiff moved to direct Connor toward processing, Connor stopped. He turned to face Evelyn Marsh at the plaintiff's table. His attorney moved to intercept. Connor raised one hand, just a hand, raised without drama, asking for a moment. He looked at Evelyn. She looked back at him with the same patience she had carried into this room that morning. The patience of a woman who came prepared for a long day and has now watched it arrive exactly where the truth required it to arrive. He said, "I'm sorry. Not for legal reasons. I'm just sorry." Evelyn held his gaze. She did not nod. She did not speak. She did not look away. She simply held his eyes open, with the specific steadiness of a person who has decided that the most honest thing she can offer right now is not forgiveness and not anger, but simply her gaze, steady and open, until he finds he can no longer hold it. He looked away first. The bailiff completed his approach. Connor picked up his portfolio from the defense table. It looked different now, smaller, like an object that belonged to a version of the morning that no longer existed and hadn't yet figured out where it fit in the one that had replaced it. The mayor's office issued a public statement the following morning. Full cooperation with the court's orders confirmed. Connor Dalton voluntarily stepping back from his seat on the city's Economic Development Advisory Board for the duration of his probationary requirements. The statement did not mention Evelyn Marsh by name. 4 weeks later, Evelyn's phone rang. Her landlord, calling directly. He didn't reference the letter. He simply said the lease would be renewed and that he'd have the paperwork ready by end of the week. The insurance carrier closed its review without action. No finding made against the shop, following receipt of the retraction letter. The review closed as though it had never been opened. Evelyn Marsh is back at full capacity on Carver Street. Same corner, same hours, same work. The cutting table she bought secondhand from an estate sale the winter before Connor Dalton ever walked through her door, refinished by hand over 2 weekends in her kitchen, is back against the east wall, already covered in the organized scatter of a person who knows exactly where everything is. The shop is open. I keep a note about this case in the top drawer of my desk, not as a reminder of the phone call, or the 47 seconds of hold music, or the tears at the defense table. I keep it as a reminder of what the false police report actually was, named precisely as Evelyn named it herself. Not an overreaction, not a mistake, a strategy. The deliberate use of institutional process as a weapon against someone who could not easily defend against it. And the reason this bench exists, to make that strategy not worth attempting. I want to say something directly to everyone watching. When Connor Dalton placed that leather portfolio on my defense table that morning, it was a signal. It said, "I belong here. This room is familiar to me. I know which surfaces to place things on, which offices to call, which names carry enough weight to reroute what would otherwise be consequence." What the portfolio could not carry was an answer to a simple question. What did you actually do? Because by the time Evelyn Marsh described it, 14 years, $6,000, a domestic sewing machine on a folding table, wedding dresses and job interview suits, and 3 people employed from the surrounding neighborhood, what Connor Dalton had done was no longer a legal question. It was a moral one. He did not fracture her sewing hand because he was a monster. He did it because his entire life had taught him that consequence has a reroute. If you know which offices to call, which names to say, which forms to file first. He had never once been in a room that told him otherwise, until that morning. This courtroom is that room. It is that room for Evelyn Marsh. It is that room for every person who walks through that door, holding something carefully, because they have learned, without being taught, that they will eventually need to prove what they are worth. A mayor's name is not a larger story than 14 years and $6,000 and a cutting table refinished by hand. It is a smaller one. If this story stayed with you, if it reminded you that the room matters, that the room can hold, Share it with someone who needs to hear it today. Evelyn Marsh is on Carver Street. The reading glasses are on their beaded chain. The work is on the table. The shop is open, the way it always has been.
The way it will continue to be.